This is my series of slides on the subject of judgments. This is for the benefit of students of Philippine civil procedure. This set of slides is part 1 of 7 slideshows. These presentations are very concise to keep your attention and to help you remember better. Let's start with part 1, which deals with judgments after pretrial. The regular flow of ordinary civil procedure begins when the plaintiff files a complaint. The court then serves summons upon the defendant, after which he files an answer. This is followed by pretrial, and then trial, and then judgment. Trial is held so that the parties can present evidence to prove factual issues. After trial, the court renders a judgment or a decision. However, there are a few instances when a trial is not necessary. From pre-trial, the court can already render a judgment. So trial is dispensed with in this case. And when does this happen? These situations are found in Section 10 of Rule 18 of the Rules of Court, which concerns judgment after pre-trial. Let's take a look at these 4 situations. The first is when there are no more controverted facts. Second, when there is no genuine issue. Third, in the absence of any issue. And fourth, when the answer fails to tender an issue. You may think that these are the same situations. However, when you examine each of these 4 situations, you realize that they are not the same at all. Let's take the first situation. There are no more controverted facts. By the use of the phrase no more, this means that in the beginning, there were controverted facts. The plaintiff raised clear allegations against the defendant to establish a cause of action. The defendant submitted an answer that squarely contests the plaintiff's allegations through denials and affirmative defenses. As you know, during pretrial, the parties are allowed to enter into stipulations of fact. This means that they agree on certain factual matters so that there will be no need to present evidence anymore on those matters. Let us say that the parties have stipulated on all material allegations of fact. This means that there is no factual issue to be tried. Evidence doesn't have to be presented. All that is left for the court to do is to decide the case. This will result in a judgment after pretrial. Second, there is no genuine issue. There seems to be an issue, but it's not a real issue. This means that when you look at the complaint and the answer, there appears to be an issue that the parties are fighting for. However, when you examine the affidavits, depositions, and supporting documents submitted by the parties, you realize that the issues are not genuine. Let us suppose that ABC Bank filed a complaint against XYZ Company for a sum of money for failure of XYZ to pay its loan on due date despite written demand. The loan is covered by a promissory note executed by XYZ in favor of ABC Bank. In its answer, XYZ Company stated that the loan has not fallen due because there is no maturity date stated in the promissory note. Under the law on obligations and contracts, when the demand letter was received by XYZ, the obligation became overdue and unpaid. And furthermore, XYZ did not deny having borrowed money from ABC Bank. As you can see, although there appears to be an issue, it is not genuine. And the next situation is absence of any issue. There is no contention between the parties. The defendant is admitting the claims of the plaintiff. And the next one, the fourth situation, is when the answer admits or does not specifically deny the allegations in the plaintiff's complaint. This means that the answer fails to tender an issue. The situation deals with technicalities of the rules of procedure. There are certain prescribed ways of making specific denials. One way is by direct denial, in which the defendant will say not only that he specifically denies the allegation in a certain paragraph in the plaintiff's complaint, but he must also state the truth of what he believes the situation to be. If he merely states that he specifically denies an allegation without stating what the truth is, as far as he is concerned, then he is deemed to have admitted that allegation. The other way of making a specific denial is by when it involves an actionable document. This means that there is a complaint, and the complaint is based either on a contract or a promissory note or some other document. When the defendant wants to contest the genuineness and due execution of the actionable document, he must deny the same in the answer and put the answer under oath. Even if he denies the genuineness and due execution, however, he does not put the answer under oath, then he is deemed to have admitted the genuineness and due execution of the document. Right, now let's have an example. Let's say that the plaintiff files a complaint for a sum of money, and the defendant in his answer says, I have no money now, I will pay when I am able. If you analyze this answer, he is not really denying any liability. In fact, he is admitting the liability, and therefore there is no issue as to his liability. This is one situation when the court can render a judgment after pretrial. In what instances can the court issue a judgment after pretrial? Let us see. If you were truly listening to this lecture, then let's take a self-quiz. Fill in the blanks in the following. Number 1, when there are no more blank facts. Number 2, when there is no more blank issue as to material facts. Number 3, when there is an blank of any issue. Number 4, when the answer fails to blank an issue. And now let's see if you got the answers correct. Number 1 is when there are no more controverted facts. Number 2 is when there is no more genuine issue as to material facts. Number 3, when there is an absence of any issue. And number 4, when the answer fails to tender an issue. Finally, your memory aid for these is CGAT, CGAT. That's C for controverted, G for genuine, A for absence, and T for tender. That's all for now, and I will be seeing you next time.